Officer Marcus Hewitt had been with the Cleveland Police Department for 6 years when he walked into a situation that would destroy his career and cost the city $4.7 million. He was 29 years old, experienced enough to know better, but apparently convinced that his authority was absolute and his judgment infallible. One quiet Thursday evening in Cleveland Heights, he received a call about a suspicious person allegedly breaking into a house in an upscale neighborhood, and decided that a black woman taking out her trash couldn't possibly be the homeowner. What Huitt did next, ignoring her house keys, dismissing her federal judicial credentials, and arresting her on her own property while neighbors recorded everything, would become a textbook example of how racial profiling destroys careers and communities. The woman he handcuffed in her driveway wasn't just any resident. She was Federal District Judge Patricia Williams, a 22-year veteran of the federal bench who'd sentenced police officers for civil rights violations and presided over landmark discrimination cases. And the arrest he made that evening would trigger a federal investigation, end his career, and expose a pattern of complaints the Cleveland Police Department had ignored for 6 years. A black woman in her early 60 seconds, Judge Patricia Williams, was wheeling her trash bin from her garage to the curb on a quiet residential street. Her house keys hung from a lanyard around her neck after just returning from evening court sessions. No crime, no violation, no disturbance, just a federal judge doing household chores at her own home. But Officer Hewitt saw her through a filter so distorted by assumptions about who belongs in expensive neighborhoods that he couldn't process a black woman as a legitimate homeowner. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Maple Ridge Drive sits in Cleveland Heights' most expensive residential area, where Victorian mansions and Tudor revivals line tree-canopied streets. It's the kind of neighborhood where property values start at $800,000 and climb from there. Doctors, attorneys, executives, and the occasional federal judge. Wide front lawns, circular driveways, and the sort of quiet that only comes with distance from main roads and proximity to serious money. It was 6:38 p.m. on a Thursday in October. The autumn air carried the smell of burning leaves. Streetlights had just flickered on, casting long shadows across manicured lawns. Children's bicycles sat abandoned on driveways while families finished dinner inside houses that glowed warmly against the approaching darkness. A UPS truck rumbled down the street, making final deliveries of the day. This was Cleveland Heights at its most peaceful. The kind of evening when nothing dramatic typically happens, when the most excitement might be a neighbor walking their golden retriever or someone bringing in packages left on their front porch. The demographic was overwhelmingly white, overwhelmingly affluent, and overwhelmingly convinced that serious crime happened somewhere else to someone else. House number 2,847 sat on a corner lot, a restored 1920s Tudor with leaded windows and a slate roof. The driveway curved from the street to a detached 2-car garage. Mature oak trees provided privacy from the neighbors, and enough space that conversations on one property couldn't be heard on another. The kind of home that cost $950,000 and looked every penny of it. Judge Patricia Williams had been on the federal bench for 22 years. 22 years of presiding over civil rights cases, criminal prosecutions, and complex litigation that required both legal brilliance and unwavering composure. She'd handled death penalty appeals, police misconduct cases, and high-profile corruption trials that made national headlines. Her courtroom was known for efficiency, fairness, and zero tolerance for discrimination. Her colleagues called her thorough. Her law clerks called her demanding but fair. Defense attorneys called her tough but reasonable. She'd sentenced corrupt police officers to prison, including a Cleveland detective who'd planted evidence in drug cases and a Canton officer who'd used excessive force during traffic stops. She'd ruled in favor of discrimination victims against major corporations, awarding multi-million-dollar settlements to employees who'd faced workplace harassment. She'd presided over cases where racial profiling was the central issue, writing 47-page opinions that became case law cited across the country and taught in constitutional law courses at universities. In 22 years on the bench, she'd never been overturned on appeal for bias, never been the subject of a serious ethical complaint, and never backed down from a difficult decision. The Supreme Court had cited her reasoning in 3 separate civil rights decisions. Legal scholars had written articles analyzing her judicial philosophy. When police departments needed training on constitutional policing, they often used excerpts from her written opinions as teaching materials. Her most famous case involved a pattern and practice lawsuit against the Toledo Police Department, where she'd ordered comprehensive reform after finding systematic violations of citizens' Fourth Amendment rights. The reforms she mandated became a national model for police accountability. Ironically, racial profiling was the exact issue she'd spent decades addressing from the bench, and now she was experiencing it firsthand in her own driveway. Williams had graduated summa cum laude from Howard University School of Law, then clerked for a federal appeals court judge in Washington, D.C., where she'd helped write opinions on constitutional law and civil rights. She'd practiced civil rights law for 12 years before President Clinton nominated her to the federal bench in 2002. She'd received the Federal Bar Association's Award for Distinguished Service, the Cleveland Bar Association's Lifetime Achievement Award, and had been considered for the Supreme Court during the Obama administration. At Harvard Law's Advanced Judicial Training Program, she'd taught courses on civil rights enforcement to other federal judges. She'd published articles in the Yale Law Journal and Harvard Law Review on racial bias in policing. Her judicial confirmation hearing had been unanimous. Even conservative senators acknowledged her qualifications and temperament. At 62 years old, Judge Williams was exactly where she'd worked to be: respected, accomplished, and secure in a career that demanded precision and impartiality. She'd never married, dedicating herself entirely to the law. Her Cleveland Heights home was her sanctuary: 8 years of mortgage payments, landscaping decisions, and quiet evenings reading case law in a study lined with legal books. She collected vintage legal texts and hosted dinner parties for other judges and attorneys. On weekends, she worked in her garden, growing tomatoes and herbs behind a house she'd saved for years to afford. She drove a modest Honda Accord, shopped for groceries like anyone else, and took out her own trash every Thursday evening. That Thursday, Williams had just returned from the federal courthouse where she'd presided over a sentencing hearing for a bank robbery case. She'd arrived home at 5:45 p.m., parked in her garage, and changed from her judicial robes into comfortable jeans and a Cleveland State University sweatshirt. She'd made herself a cup of tea and reviewed briefs for the next day's docket. At 6:35 p.m., she remembered it was trash day. She walked to her garage, grabbed the wheeled bin she'd filled earlier that week, and began pulling it down her driveway to the curb. Her house keys hung from a lanyard around her neck, a habit developed after years of juggling case files and courthouse security requirements. Her federal judicial identification was in her wallet, which was in her purse inside the house. She looked like what she was: a professional woman doing routine household maintenance at her own home. She'd spoken to no one, bothered no one, violated nothing. She was 30 feet from her front door, pulling a trash bin she'd filled with her own garbage to a curb she'd placed trash on every Thursday for 8 years. But to someone watching from a patrol car, Judge Patricia Williams' presence in that neighborhood was suspicious, and that person had decided to investigate. Officer Marcus Hewitt was 29 years old. He'd been a patrol officer with the Cleveland Police Department for 6 years. He was eager, aggressive in pursuit of what he considered suspicious activity, but convinced that his instincts about who belonged where were infallible. His supervisors described him as results-oriented but sometimes lacking in community sensitivity. Code language for an officer who made arrests but generated complaints. In 6 years, Huitt had compiled a record that should have triggered immediate supervisory intervention. 11 complaints. 11. 7 of them involved allegations of racial profiling or excessive force against black residents in predominantly white neighborhoods. The pattern was unmistakable and documented in excruciating detail. In 2019, he'd stopped a black teenager walking home from basketball practice in Shaker Heights, detaining him for 45 minutes while verifying he lived in the neighborhood. The teen's mother was a prominent attorney. Complaint filed, training completed, case closed. In 2020, he'd questioned a black postal worker delivering mail in Cleveland Heights, demanding identification and verification of employment, even after the worker showed his uniform, mail truck, and postal service ID. The postal inspector filed a formal complaint. More training, another file closed. In 2021, He'd arrested a black man loading groceries into his car outside a Whole Foods, convinced the expensive organic groceries must be stolen despite the man producing a receipt, credit card, and store loyalty card. The man was Dr. James Henderson, chief of cardiology at Cleveland Clinic. The arrest lasted 3 hours before supervisors intervened. Dr. Henderson's complaint led to a $180,000 settlement the city quietly paid. Each incident followed an identical script. Black person in affluent area. Huitt's immediate suspicion. Aggressive questioning despite reasonable explanations. Complaint filed. Brief investigation. Sensitivity training ordered. No meaningful discipline imposed. His supervisors documented each incident with growing concern, but never connected the obvious dots. Internal Affairs had flagged his complaint pattern twice, recommending enhanced supervision and possible reassignment. Both recommendations were ignored by command staff who cited Huitt's arrest statistics and described him as an aggressive officer who sometimes needs guidance on community relations. The euphemisms in his personnel file told the real story. Tends to focus heavily on certain demographic patterns and would benefit from additional cultural sensitivity training. 3 complaints had been sustained, resulting in written reprimands and mandatory retraining. 5 had been closed with insufficient evidence, often because victims didn't have the resources to fight the department's investigation process. 3 were still under investigation when he arrested Judge Williams. But somehow Huitt remained on patrol, responding to calls in neighborhoods where his biases repeatedly created constitutional violations and legal liability. That evening at 6:32 p.m., dispatch received a call from Eleanor Murphy, an 78-year-old white woman who lived across the street from Judge Williams. Murphy had seen a black woman going through the garage of the house and was convinced someone was breaking in. She'd never met her neighbor. Judge Williams often worked late and valued her privacy, and Murphy's eyesight wasn't what it used to be. Huitt was 3 blocks away when the call came in. Possible burglary in progress, 2847 Maple Ridge Drive, suspect described as black female, approximately 60 years old. In his mind, the call confirmed everything he believed about crime patterns. Black people didn't belong in expensive neighborhoods unless they were there to steal something. He didn't consider that the suspect might live there. He didn't think about legitimate reasons for someone to be near the garage of their own home. He just drove to the location, already convinced he'd found his burglar. Huitt arrived at 6:37 p.m. His patrol car pulled slowly down Maple Ridge Drive, and his eyes immediately scanned for the suspect. He saw Judge Williams 20 feet from her house, pulling a trash bin toward the curb. In Huitt's mind, that had to be her, a black woman where she didn't belong, probably using the trash bin to carry stolen items away from the house. He didn't notice her keys. He didn't observe her casual, unhurried movements. He didn't consider that someone stealing from a house wouldn't leisurely wheel a trash bin to the curb. His mind had already filled in a narrative. Black woman, expensive neighborhood, must be a crime. He parked his patrol car and walked directly toward Judge Williams, his hand already moving toward his handcuffs. Do you think police officers should face automatic suspension after their 5th racial profiling complaint? Drop your answer below. Judge Williams was positioning her trash bin at the curb when she became aware of heavy footsteps approaching. She looked up and saw a young white police officer walking directly toward her, his posture aggressive, his expression set in determined suspicion. "Ma'am, step away from that house." Williams' first reaction was confusion. She glanced around, wondering if he was addressing someone else. There was no one else on the street. "Excuse me? I'm taking out my trash." Huitt's expression hardened. His hand moved to rest on his radio. "We got a call about someone breaking into this residence. You need to move along." Williams felt a familiar chill, the recognition that this was happening, that despite her credentials and accomplishments, she was being seen as a criminal based on nothing but her race and location. "This is my house. I live here." She lifted the lanyard around her neck, showing him her house keys. The keys were clearly visible, hanging from a judicial conference lanyard that read, "Federal District Court." The homeowner is described as an elderly white woman. You don't exactly fit that description. Williams' professional composure was being tested, but she maintained her calm tone. She'd presided over too many similar cases to let emotion override reason. The caller made a mistake. I'm Judge Patricia Williams. I've lived here for 8 years. She gestured toward the house behind her, then toward the trash bin she'd been moving. This is my garbage, from my house, that I'm placing at my curb like I do every Thursday. This is where bias becomes impenetrable. Despite the keys, despite the reasonable explanation, despite the obvious routine nature of trash disposal, Hewitt couldn't process information that contradicted his assumptions. His mind had already decided. Black woman, white neighborhood, must be criminal. Evidence to the contrary became obstacles to overcome rather than facts to consider. Hewitt looked at the keys dismissively. His expression didn't change. In his mind, criminals could have keys, stolen keys, fake keys, keys that proved nothing. The judicial conference lanyard meant nothing to him. Federal credentials could be faked. Everything could be explained away if you were determined to maintain your initial assumption. I don't care if you're the Supreme Court. You're trespassing. Across the street, Eleanor Murphy watched from her window, beginning to realize she might have made a terrible mistake. She could see the keys, the professional appearance, the obvious familiarity with the property. The burglar she'd reported was clearly the homeowner. But the police officer wasn't listening to her attempts to signal from her window. 2 houses down, Jennifer Walsh walked out to get her mail and stopped dead in her tracks. She'd lived on Maple Ridge Drive for 12 years and knew Judge Williams by sight. They'd exchanged pleasantries about gardening and had discussed the neighborhood book club. She immediately pulled out her phone and started recording, her hands shaking with anger and disbelief. "Officer, I'm showing you my house key and my judicial ID." Williams reached toward her neck, where her work ID was attached beneath her keys. The identification clearly displayed her photograph, name, title, and the federal court seal. But Hewitt's training kicked in. Reaching for something could mean reaching for a weapon, regardless of how innocuous the movement appeared. That could be fake. Hands behind your back. A teenager walking his dog stopped on the sidewalk, sensing the tension and pulling out his own phone to record. An elderly man who'd been watering his garden turned off his hose and moved closer, becoming increasingly agitated as he realized what was happening. "She lives there," Jennifer Walsh called out from her driveway. "Officer, she's Judge Williams. She's lived there for years." "This is her house," the teenager added, his phone still recording. The quiet neighborhood had gone completely still. Conversations on porches stopped mid-sentence. Porch lights flicked on as residents emerged to see what was happening. Car doors slammed as people returning from work stopped to witness the confrontation. At least 6 phones were now recording from different angles, capturing everything. "You're making a serious mistake. I am Federal District Judge Patricia Williams. This is my home for 8 years. But Hewitt ignored the growing crowd of witnesses confirming Williams' identity. He'd made his decision, and backing down now would mean admitting error in front of a neighborhood full of people with cameras. His pride, his authority, his entire self-concept as a competent officer required him to follow through, regardless of mounting evidence that he was catastrophically wrong. "Turn around and put your hands behind your back." Judge Williams knew she had a choice. She could resist and risk violence that would only escalate the situation, or she could comply under protest and document everything for later legal action. She chose documentation over confrontation. "I'm complying under protest for the safety of everyone involved. I want all witnesses to note that I'm being arrested at my own home while taking out my trash." She turned around and placed her hands behind her back. Hewitt's handcuffs clicked into place around the wrists of a federal judge. "Officer, you're arresting a sitting federal judge. Check my identification before you make this worse." But Hewitt was committed now. The crowd of neighbors was watching, recording, witnessing his decision. To back down would mean acknowledging he'd made a catastrophic error in judgment. "You'll have your chance to explain at the station. Should officers be required to verify federal credentials before making arrests? Let me know what you think." Sergeant David Chen arrived within 8 minutes. He was a 16-year veteran who'd seen plenty of officer mistakes and recommended discipline before when situations got out of hand. He approached and immediately assessed the scene. A well-dressed black woman in handcuffs, a crowd of recording neighbors, and Officer Hewitt looking increasingly defensive. "Hewitt, what's the situation?" Hewitt's explanation was defensive and rambling. Burglary call, suspicious activity, subject claimed to live here but couldn't verify. Decided to arrest for trespassing and investigation. Chen looked around the scene, the trash bin at the curb, the keys hanging from the woman's neck. the expensive home behind them, the neighbors shaking their heads in disbelief. Chen picked up the keys around William's neck and examined them closely. House key, mailbox key, judicial conference lanyard, federal ID attached. He walked to the front door and tested the key. It worked perfectly. "Ma'am, what's your name?" "Judge Patricia Williams. I'm a federal district judge for the Northern District of Ohio." Chen pulled out his phone and called the federal courthouse. Within 2 minutes, he'd verified her identity, her position, and her address. He walked back to Huitt with something cold and dangerous in his expression. "She's exactly who she says she is, Huitt. She's a federal judge, and this is her house." Chen turned to Huitt with barely contained frustration. "Badge and weapon. Administrative leave effective immediately." Hewitt's face went pale. His hands started shaking as he realized the magnitude of what he'd done. "Sergeant, I was responding to a call. I followed protocol." Chen's response was sharp and final. "You arrested a federal judge for taking out her own trash. You ignored her keys, dismissed her ID, and proceeded despite multiple witnesses telling you she lived here. Give me your badge." Huitt handed them over with trembling fingers. For the first time, he seemed to understand the career-ending nature of his decision. Chen removed Williams' handcuffs and turned to face her directly. "Judge Williams, I apologize on behalf of the Cleveland Police Department. This should never have happened, and there will be consequences." Williams rubbed her wrists where the handcuffs had been, her judicial composure intact but her anger unmistakable. "Sergeant, I appreciate the apology, but this represents a larger pattern. I'll be documenting everything, consulting with attorneys, and this incident will be reported to federal authorities for civil rights investigation. Should officers face automatic termination after wrongful arrests of federal officials? Drop your answer." Within 6 hours, the videos had exploded across social media, with a force that surprised even the witnesses who'd recorded them. Multiple neighbors had captured different angles, and the footage showed everything. Huitt, ignoring the keys, dismissing the federal ID, and arresting a respected federal judge in her own driveway while she calmly explained his mistake. The hashtags number Judge Williams arrest and number Cleveland Police began trending nationally within 4 hours. The videos had been shared 2.3 million times across platforms by midnight. Cable news picked up the story by morning. Legal commentators expressed outrage. Police accountability advocates called it a perfect example of systemic bias. Cleveland cop arrests federal judge taking out trash at her own home. Racial profiling exposed. Sitting judge handcuffed in her driveway. Cleveland police face federal investigation after judge's wrongful arrest. Caught on video. Officer ignores keys, arrests homeowner. The outrage was immediate and intense, amplified by the victim's credentials and the clear documentation of every moment. The NAACP issued a statement condemning the incident and calling for comprehensive police reform. The Federal Judges Association called for mandatory civil rights training for all law enforcement. The Cleveland chapter of the National Bar Association demanded immediate accountability measures, but the most damaging response came from the legal community itself. Federal prosecutors who'd appeared before Judge Williams expressed outrage. Defense attorneys who'd argued cases in her courtroom called the arrest unconscionable. The Ohio State Bar Association issued an unprecedented statement calling for federal intervention in Cleveland's police department. Legal blogs dissected every moment of the videos, pointing out each constitutional violation, each departmental policy breach, each moment when Huitt could have de-escalated but chose aggression instead. Law professors assigned the case to students as an example of everything wrong with American policing. The story became international news when the BBC picked it up as an example of American racial tensions. Asterisk, asterisk, immediate consequences for Huitt. Asterisk, asterisk. Hewitt's life imploded within 48 hours. Administrative leave, internal affairs investigation launched, media identifying him by name. The Cleveland Police Union initially issued a statement supporting him, but withdrew it after reviewing the video evidence. His social media accounts were deleted after receiving thousands of angry messages. Huitt released a brief statement through an attorney. "I regret any misunderstanding and was following what I believed to be proper procedure." The statement satisfied no one. Judge Williams contacted the ACLU and filed a federal civil rights lawsuit 3 weeks later. The lawsuit named Officer Hewitt, Sergeant Chen, the Cleveland Police Department, and the City of Cleveland. The claims were comprehensive and damning. unlawful arrest and false imprisonment, civil rights violations under 42 U.S.C. Section 1983, racial profiling and discrimination, intentional infliction of emotional distress, municipal liability for failure to train and supervise, pattern and practice of constitutional violations. The complaint included Hewitt's complete disciplinary record, 11 complaints over 6 years, 7 involving racial profiling, 3 sustained complaints, all resolved with training that never changed behavior, a pattern the department had documented but never addressed with meaningful discipline. Cleveland's attorneys reviewed the case and reached the same conclusion: indefensible. Multiple videos from different angles, clear evidence of racial profiling. A federal judge is the victim. A documented pattern of similar complaints. No viable defense strategy. The city settled 6 months later. $4.7 million paid to Judge Williams. Plus, the city was required to implement federal oversight of its complaint process, mandate implicit bias training for all officers, and create a civilian review board with subpoena power. Huitt was terminated 8 weeks after the incident. The termination letter was direct and comprehensive. Officer Hewitt demonstrated a pattern of racial profiling that culminated in the unlawful arrest of a federal judge at her own residence. His actions violated departmental policy, constitutional law, and basic standards of professional conduct. His employment is terminated without appeal. Hewitt's name was entered into the National Decertification Index, preventing him from working as a police officer anywhere in the United States. His 6-year career ended at age 29 without pension or benefits. The police union reviewed the evidence and declined to challenge the termination. Huitt never released another public statement and moved out of Cleveland within 3 months. Judge Williams testified before the Cleveland City Council during public hearings on police reform. Her testimony was measured, authoritative, and devastating. I've been a federal judge for 22 years. I've presided over civil rights cases, sentenced police officers for misconduct, and written opinions on racial profiling that have become precedent in courts across the country. She paused, letting her credentials settle in the minds of everyone listening. On October 18th, I was arrested at my own home while taking out my trash. Officer Hewitt ignored my house keys, dismissed my federal identification, and handcuffed me in my own driveway, despite multiple neighbors confirming I lived there. Another pause, her voice carrying the weight of authority earned through decades of judicial service. But this isn't about one evening or one officer. Officer Hewitt had 11 complaints in 6 years, 7 involving racial profiling. That's not bad luck. That's not isolated incidents. That's a pattern your department documented but never meaningfully addressed. Her voice strengthened, carrying both judicial authority and personal outrage. The city paid $4.7 million. That's significant accountability. But money doesn't restore the dignity of being handcuffed on your own property because someone decided you didn't belong in your own neighborhood. She looked directly at the city council members. I'm a federal judge with 22 years on the bench, degrees from prestigious universities, and the legal resources to fight back. If this can happen to me, with my credentials and my resources, what happens to people without federal judicial immunity? What happens to the teenager walking home from school, or the postal worker delivering mail, or the grandfather loading groceries? The chamber was silent. That's the question this incident forces Cleveland to answer. Should racial profiling in residential neighborhoods trigger automatic federal civil rights investigations? Drop your answer. This wasn't just about one October evening or one officer's catastrophic judgment. This was about a department that let Marcus Hewitt accumulate 11 complaints over 6 years without meaningful intervention, and a system that treats racial profiling as a training issue rather than a termination offense. This was about a culture where supervisors document patterns of bias but never act on them, where community sensitivity training becomes a substitute for accountability, and where officers learn that complaints are obstacles to overcome rather than warnings to heed. It was about a department that paid $180,000 to settle Dr. Henderson's case but kept the officer who arrested him on patrol. It was about a system where being wrong repeatedly carries no consequences until you're wrong in front of too many cameras to ignore. Hewitt's disciplinary record told the story his supervisors chose to ignore, a story written in complaint after complaint, training session after training session, Incident after incident that followed an identical script. 11 complaints over 6 years, 7 involving the same pattern. Black people questioned for existing in white spaces. Every complaint dismissed with sensitivity training that never changed behavior. Every incident treated in isolation, never connected to the obvious pattern of constitutional violations. The documentation was extensive and damning. Internal Affairs had flagged his behavior twice. Supervisors had noted his demographic focus. Command staff had recommended additional oversight. But somehow, none of that documentation translated into meaningful action. Instead, it became a paper trail of institutional failure, evidence that everyone knew there was a problem, but no one was willing to solve it. The pattern was unmistakable. Huitt saw black people in affluent neighborhoods as inherently suspicious. He questioned their right to be there, demanded proof of belonging that he never required from white residents, and escalated routine encounters into constitutional violations. But Cleveland police treated each complaint separately, never acknowledging that 7 incidents of racial profiling by one officer in 6 years represents systemic failure, not individual mistakes. Marcus Hewitt's career is over. That's consequence. The city paid $4.7 million. That's accountability. He'll never work as a police officer again, anywhere in America. That's justice. His name is now permanently in the National Decertification Index, following him for the rest of his life. That's a permanent record of his failure. But terminations and settlements don't undo the trauma of being handcuffed on your own property because someone decided you didn't belong in your own neighborhood. Money doesn't restore the dignity of being treated as a criminal for taking out your own trash. Consequences don't erase the message sent to every black resident that their presence in certain neighborhoods will always be questioned, always be suspect, always require justification. Federal oversight doesn't change the fact that it took arresting a federal judge, someone with ultimate credibility and unlimited resources, to trigger meaningful accountability. It doesn't address what happens to the postal workers, the teenagers, the grandfathers who don't have judicial immunity and federal legal protection. The real question is, what changes now? Do police departments finally remove officers after 5 complaints instead of 11? Do they finally connect the dots at complaint 3 instead of complaint 7? Do supervisors finally acknowledge that some officers bring biases that no amount of training can overcome? Do we finally recognize that community sensitivity training is meaningless without accountability measures that have teeth? Do departments finally understand that patterns of racial profiling aren't training deficits? They're character flaws that disqualify someone from carrying a badge and gun? Because if we don't fix the system that allowed Huitt to rack up 11 complaints while remaining on patrol, if we don't address the culture that treats racial profiling as a correctable mistake rather than a disqualifying character flaw, if we don't acknowledge that some biases are too dangerous for public safety, then we're just waiting for the next Marcus Hewitt, the next Patricia Williams, the next evening when someone's assumptions collide with someone else's constitutional rights. The federal oversight mandate requires Cleveland police to track complaint patterns, implement early warning systems, and remove officers who demonstrate repeated bias. But those requirements only exist because Judge Williams had the credentials and resources to demand them. What about officers whose victims don't have judicial immunity and constitutional law degrees? Comment if you believe this should be law. Police officers who accumulate 5 racial profiling complaints in 3 years face automatic termination with entry into the National Decertification Index. And if you think these stories need to be told, if you believe accountability starts with exposure, then hit that subscribe button. We're not stopping. We're going to keep exposing the patterns that departments hope no one notices. We're going to keep demanding better for communities that deserve constitutional policing. This isn't just about one racist cop or one federal judge. It's about all of us and the society we're willing to accept. Because when taking out your trash becomes grounds for arrest, when house keys become insufficient proof of residence, when federal credentials get dismissed as fake, then no one is safe from the assumptions that turn neighbors into suspects and homes into crime scenes.